How can revocable or irrevocable trust be applied to Medicaid planning? Attorney Kellen Bryant explains. All trust will have to be analyzed by the elder law attorney who you are working with. The trust will be reviewed by the Department of Children and Families in Florida, which will administer the Medicaid rules and determine eligibility. There are two main categories of trust that can be generally addressed. The first type is the revocable living trust. Under the Florida Medicaid rules, if the applicant has created a revocable living trust and has put assets into that trust, then the assets are countable if they are normally countable under the Medicaid rules. In other words, revocable trusts do not protect assets in the state of Florida. That is a very common misconception. If the revocable trust has assets in the name of the trust that are considered non-countable, then the assets are not countable. Countable assets held and owned by the revocable trust, such as savings bonds, checking accounts, savings accounts, money markets, cash value annuities, cash value life insurance, mutual funds, and so forth, are going to be subject to the spin-down rules for Medicaid. The irrevocable trust, however, will be construed in a different way. Depending on the wording, irrevocable trust may not be countable. The types of irrevocable trusts that are not countable are what are typically referred to as irrevocable income-only trusts. These trusts have the basic component that they are created by the Medicaid applicant, and that the applicant put the assets in the trust more than 5 years ago. The trustee cannot use the principal from these assets to pay directly to the Medicaid applicant. So, the Medicaid applicant is irrevocably giving away the rights to principal more than 5 years old, and Medicaid will not count these assets in the trust. So, if someone put $500,000 in a revocable trust today and gave up the right to principal, then 5 years from today, those assets would not be considered countable under Medicaid rules. The other type of irrevocable trusts that are commonly not countable are special needs trusts, which are irrevocable. Special needs trusts are generally worded so that the trustee cannot put the trust assets directly in the Medicaid applicant's account. However, the trustee can directly use the trust money to buy things for the benefit of the Medicaid applicant. In most cases, if you are looking to preserve assets using an irrevocable trust, then you are looking to do so with a degree of advanced planning. At a minimum, I would typically recommend beginning an irrevocable trust at the beginning of a diagnosis, or when a family notices a decrease in independence, mobility, or capability in terms of physical and mental actions involving the management of money. Put your mind at ease and make an appointment to meet with the Berg Bryant Elder Law Group in Jacksonville, Florida today.